I'm Mike Hackard with Hackard Law. When a loved one passes away, families are immediately confronted with loss. What often follows is a period of uncertainty, questions about assets, debts, responsibilities, and the legal process that governs the settling of an estate. For many families, this is their first introduction to probate, and in that moment, one question rises quickly to the surface. How much will this cost? It's a fair question. Probate can feel unfamiliar. Choosing a lawyer during a difficult time can feel overwhelming, and the idea of adding financial pressure to an emotionally challenging season can make families hesitate. But after more than 40 years representing families in probate and estate matters, I can say with confidence the cost of a probate lawyer is only one part of the equation. The value in clarity, protection, and peace of mind is what truly matters. To understand the cost, we first need to understand the role. Probate lawyers guide families through a detailed legal process that includes validating the will, opening the estate, identifying and securing assets, paying debts and taxes, resolving creditor claims, addressing questions among beneficiaries, and ultimately distributing the estate according to law. Some cases are straightforward. Others involve blended families, conflicting instructions, significant assets, or disagreements that require court intervention. In every case, the lawyer's purpose is to protect the estate, support the executor, and ensure the process is completed lawfully and efficiently. Let's look at how lawyers typically bill for probate work. The first structure is hourly billing, common when a case involves uncertainty or potential disputes. Rates vary widely depending on geography and experience, ranging from a few $100s per hour to higher levels in complex metropolitan cases. While hourly billing can feel open-ended, it allows clients to pay only for the time actually spent, and it's often suitable for estates with changing needs. Another method is a flat fee. Some estates, particularly those that are modest and uncontested, can be handled for a predictable, all-inclusive amount. Families often appreciate the clarity of a flat fee, though it may not cover complications that arise later. In states like California, statutory fees apply. These are set by law and tied to the gross value of the estate. While transparent and predictable, statutory fees can feel counterintuitive, since they are calculated without regard to debt or equity. Still, they provide a clear legal standard that benefits both executors and attorneys. In a smaller number of cases involving probate litigation, recovering assets, contesting a will, or addressing financial wrongdoing, contingency fees may be used. This means the lawyer is paid a percentage of what is recovered. Though rare in standard probate, it can be an effective tool in high-stakes disputes. Beyond billing structure, several factors drive the overall cost of probate. The size of the estate, the complexity of assets, the level of organization left behind, the likelihood of conflict, and the number of court filings required. Larger or more intricate estates naturally involve more time. Estates with outdated documents or unclear records require additional investigation. And when disagreements arise, costs can escalate quickly. But there's another side to this story, the hidden cost of trying to manage probate without proper guidance. Families often attempt to save money by handling probate alone or by using low-cost services that lack experience. Unfortunately, probate law is precise. Missed deadlines, incomplete filings, or misunderstandings about notice requirements can slow the process dramatically or even place executors at personal risk. Without legal support, what begins as a simple intention can become a prolonged struggle, draining both the estate and the family's emotional reserves. In contrast, the right lawyer provides clarity. A knowledgeable probate attorney anticipates issues, organizes the process, keeps communication steady, manages court filings, and brings structure to what can otherwise feel overwhelming. They act as a stabilizing force, protecting the estate from unnecessary tax exposure, guiding executors through decision-making, and reducing the possibility of conflict among beneficiaries. This clarity has real measurable value. Families often tell us that what they appreciated most was not simply the legal work, but the confidence they felt, the knowledge that someone experienced was guiding the process, the knowledge that mistakes were avoided, and the knowledge that they could focus on their loved ones rather than stressing over filings, deadlines, and disputes. I've seen the difference this makes firsthand. In one case, an executor attempted to manage a complex estate independently. Deadlines were missed, accounts were frozen. A misunderstanding with a beneficiary eventually escalated into litigation. By the time the family sought help, unnecessary costs had multiplied and relationships were strained. In contrast, a similar estate we handled from the outset closed smoothly, with clear communication, timely filings, and full compliance. The cost was far lower and the family remained united. The lesson is simple. Probate is not just a legal process. It is a time when families need steady guidance and clear structure. A probate lawyer is not merely an expense. They are an investment in peace of mind. If your family is navigating probate, or you expect to soon, you deserve clarity. You deserve protection. And you deserve a process grounded in experience, compassion, and precision. I'm Mike Hackard. Thanks for watching.